The purpose of this video is not necessarily how to explain it, which is what my prior video was, but this is so you have an in-depth understanding of what each paragraph of the residential sales contract states. This particular version I'm working off of is from January of 2021. If you have a prior one, it could be different. If there's a subsequent one, it will be different. So it's important to keep that in mind. In the preamble, the most important thing on there is obviously that you have the seller's names correct and you have the buyer's names correct as of the date. The date is an important trigger for other items after the contract, so you want to make sure that's accurate. It'll also stipulate in there who works for who. So in our case, if we're working for the buyer, that box will be checked, or it'll be checked for who's working for the seller. Paragraph 1, real property. You can find this information. This is the legal description. It's important that this is accurate, especially the address. This can be found in the tax record, but it's mainly the street address, the unit number, city, zip code. That's the most important part. Paragraph 2, financing and the price of the property. I always prefer to express them as percentages, because if they're expressed as percentages, there's fewer cross-outs as we counter back and forth. So paragraph 2, subparagraph A is the down payment. The down payment would be expressed as a percent, 5%, 10%, 3%, whatever that may be. Paragraph B is going to check the type of financing that it's going to be. What type of loan is this? Conventional, VA, FHA, or other type of loan, and it'll be how much is being financed. So if they're putting down 5% and they're going to finance 95%, that's how you would express that in the contract. Subparagraphs 2 and 3 deal with the second trust financing. It's a little different. If that comes up, we can discuss that, but for the purposes of this, I'm just going to go ahead and omit that. Right after paragraph 3 talks about total financing. That's going to be the total financed amount expressed as a percentage. So if you have a first trust that's 80% and a second trust that's 10%, the total amount financed is 90%. If you just have a first trust and it is 90%, then you just put 90% down there. Underneath that is the important one. That's the total sales price, and that reflects the exact amount that you're offering for the property. Paragraph C, seller subsidy, refers to any subsidy that you're asking for. It's always better to express that as a specific amount. $2,000, $10,000, something of that nature. You could express it as a percent. Always safer to ask for a specific amount. It's always important to note too that whatever you ask for in there, if you ask for $10,000 and the contract is negotiated accordingly and accepted, and then the lender only comes up with $8,000 worth of fees, then that's $2,000 you've lost on behalf of your client. You don't get that credit, that settlement for the difference. So good to know if you're asking for closing costs, talk to the lender and find out how many legitimate closing costs there's going to be and work from that. But accuracy is important on that. Paragraph D stipulates this contract is or is not contingent upon financing. If the contract is contingent upon financing, the buyer agrees to make written application for the financing and any lender-required property insurance no later than 7 days from ratification. It's an important distinction to note. They can't mess around. The assumption is that most buyers have already begun the loan process ahead of time. If they haven't, they need to make sure it's done within 7 days. This paragraph also is where the buyer grants permission for the cooperating brokerage and the lender to disclose to the listing brokerage and seller general information about the progress of the loan application and the loan approval process. This is where we're giving the lender permission. If we're representing the buyer, we're giving the lender permission to disclose ongoing facts about the loan. If we're on the listing side, it gives us permission to talk to the other lender about the status, where we're at, how we can help, that type of thing. And it also is where the seller is agreeing. It's important. If we're on the buying side and the seller's being tough to deal with, Seller agrees to comply with any reasonable lender requirements. So if the lender wants to do a second appraisal, they can't get their back up and decline access, they're obligated to do that. Paragraph 3 is where the buyer's deposit is noted. This is usually held by the title company. That's where we hold ours, and has to be delivered to the title by either check or bank wired funds. Can't just arbitrarily show up with cash, and they're considered the escrow agent. The way that we prefer to do it is we deliver the deposit to the escrow agent within X number of days after the date of ratification. So the first sentence specifies the amount of the deposit and then stipulates how it's going to be delivered. Is it already delivered to them, or will it be delivered within X number of days after the ratification of the contract? Funds that are delivered there may or may not be held in an interest-bearing account. As a buyer, you're waiving rights to any of the interest that may be collected, which is negligible at this time. In anything specified in there, it has to be delivered to the escrow agent within 5 days, irregardless of whatever's in there. It has to be there within 5 days. That money is sacred money. That money does not come out. It is held by the escrow agent until either a judge orders its disposition, or it is credited to the buyer's funds at closing, or both buyer and seller agree to its disposition in writing. Those are the 3 ways that money can come out of there. This paragraph also holds the escrow agent free of any liability related to that money that comes out, unless it's through gross negligence on their part. It's important to note, every buyer is concerned about that money. That money doesn't go anywhere until one of those 3 things occurred. So if for whatever reason that property doesn't settle, then we have to get all the documentation so that that money gets refunded. Paragraph 4, seller and buyer will make full settlement in accordance with the terms of this contract on or with mutual consent before. This is the line where we put in there the date of settlement. That is the date that settlement occurs, unless for some reason you put in a Sunday and then it goes to the last business day prior to the weekend. So it would go to that Friday. Or if it's a holiday, it goes to the day before. That's automatic in this. As a buyer, you have the right to select the settlement agent in the transaction. We use RGS Title. They perform the title search on the property. Oftentimes the seller wants you to use their title company because it saves some money or something along those lines. They're an important part to this, so we need to retain control of that. But it's important distinction that in Virginia, you do not have to have an attorney present at settlement. It can just be a settlement agent. At RGS, it's Bill. Bill is a licensed attorney, so we get the benefit of that. However, we may have home field advantage with Bill, but push comes to shove, he represents the contract. He does not represent either the buyer or the seller in that regard. They're technically not supposed to provide legal advice. They are there to represent the terms of the contract. And legal advice, one way or another, they're not unless they're formally retained by somebody. One of the lines that's specific to this contract is it says the seller may not require the use of a particular settlement agent as conditions on the sale of that property. They can have their preferred, it can make it, but they can't dictate or make somebody take that. They cannot take a contract with someone that is with a company that they don't like, but they're not allowed to force somebody into that. In this paragraph is the buyer who gets to select, and the buyer will designate who they want that settlement company to be. The buyer agrees to contact the settlement agent within 10 days of the date of ratification to schedule settlement. Settlement agents shall order the title exam and the survey if required. It's always going to be required, so they're going to order it probably at that 10-day mark. As an office, as soon as we get the contract, we're alerting them to the settlement, that the settlement's coming. We will try and schedule it. I usually go for the first one in the morning that's available, which is either 9 or 9:30 or 10. I go for the first one so that if there's any delays on, if we have one that's ahead of us, if there's any delays, we're not pushed out into noon or something like that. We try and be the first one so that we can settle and get ours over and done with. This is, you're authorizing the settlement agent to send closing disclosure to buyer by electronic means and agree to provide settlement agent buyer's electronic email. This is simply specifying how things are going to go back and forth from the title company to us. Paragraph 5, down payment. The balance of the down payment will be paid on or before settlement date by certified or cashier's check or bank wired funds as required by the settlement agent. An assignment of funds shall not be used without prior written consent of the seller. What that means, an assignment of funds, is where a buyer has sold their house and they're going to assign the funds from that settlement to our settlement. That actually is a delay in recordation. So if that's the case, we need to get prior written consent. And also, the buyers can't show up with cash. They can't sit there and show up with a suitcase load of cash and expect settlement to occur. Needs to follow the proper procedure, and I guess the IRS needs to be able to track the source of the funds. Delivery. There are general delivery requirements specified under the contract. This part does not deal with the Property Owners Association or the Condominium Act. They're covered elsewhere. Residential Property Disclosure Act is also elsewhere. But these are any other delivery, anything else related to the contract. This is how delivery is to occur. And it specifies the methods may include hand carry, sent by professional or courier service or United States mail, by facsimile or by email transmissions. The parties agree that the delivery will be deemed to have occurred on the day that it is delivered by hand, delivered by a professional courier service, or by the United States mail with return receipt requested, or sent by facsimile or email transmission. So emails and faxes are deemed to be proof of delivery. So any documents, that's why we don't save our faxes anymore, but we certainly save our emails, and if you have a fax machine, you could still use that, I guess, as long as they have a fax on their hand. We always use our email. Down in 6A, it specifies where we want that to go. If we're representing the seller, we use our email address. I don't want the buyers delivering something to the seller directly. Likewise, if it's our buyer, we put our emails in there instead of the buyers. We don't want them delivering documents or addendums to anybody other than us. So it comes to our clients from us. Important to note, no party to this contract will refuse delivery in order to delay or extend any deadline established in the contract. Important little sentence there. Property Owners Disclosure Act. This mainly deals with the acceptance, but the property disclosure, which is a form I'll go over later, where the seller is basically disavowing themselves of any knowledge and of anything that's wrong with the house, but that it has to occur prior to acceptance of the contract. So on our listings, we scan that and put that in other documents. Most of the other agents do something similar, but when you're writing a contract, we need to have that disclosure signed before the contract is signed. So that's the first document to get signed. If we don't have one, we can fill out a blank one and accompany the contract. Ideally, you want one signed by the other side first. If an agent hadn't put it up there, you can call and ask them, but I wouldn't let that delay the presentation of the contract. The law requires the seller on a disclosure statement provided by the board to state that they make no representations or warranties concerning the physical condition of the property and sell the property as is, except as otherwise provided in this contract. The disclosure statement is delivered to buyer after the date of ratification. Buyer's sole remedy shall be to terminate this contract. If the buyer gets it ahead of time, they can't terminate the contract. They shouldn't have written the contract. But if they get it after the contract has been ratified, that's a way to get out of the contract. The paragraph there stipulates it can be within 5 days after the postmark or 3 days after it's delivered in person, etc. Rare that happens. If they're going to terminate the contract, written notice of termination follows the delivery protocols. It has to be hand delivered, sent by United States mail. prepaid as long as the buyer retains sufficient proof of the mailing, which is either by United States blah 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 blah, or sent by electric means or fax. Any such termination will be without penalty to the buyer. So if you have a ratified contract, then they deliver a disclosure that needs signed, and you sign it. The buyer has 3 days to get out of that. They can walk away unscathed. Property owners associate, and that what that's for, and I'm forgetting that I'm not just explaining this, but why it is. That's so they have adequate time to read the docs and find out that, you know, there's no violations, that the neighborhood's financially secure, that there's not rules that prohibit them from doing something within the property, you know, like driving a company truck. You know, you drive a company truck and you're not allowed to park in front of your house. That's not cool. So they might not want to buy the property. Property Owners Association Act. Property Owners Association Act, that's kind of what I was alluded to there, is the property owner. This is where they're stipulating that the seller represents that the property is or is not located within a development that's covered by that. The owner is in one, required to give us a current set of the homeowner association documents. Not supposed to be more than 90 days old, I think, is the legalese, although that's not spelled out in here. But it has to be a current set. Long story short, they couldn't deliver the set that they got when they bought the house 5 years prior, or 3 years prior, or even a year prior. It has to be a current set. In those documents, in the next paragraph, that'll state where they're delivered. We always put their email address in there as well as our email address in there, so that A, we have a copy of it, but B, so that the buyers have to get a copy of it. Because if we just put our email address in there and they email it to us, and then we don't get it to our buyers for 24 hours because they're out on a cruise somewhere or they're unavailable, then we've got a delivery issue if they want to get out. It messes up the time frame. So we put their email address in there as the first one, followed by our email as the second one. As soon as those go, we're on a time frame. Look through them. Don't wait until the next day or wait until you're back in town or any of that kind of stuff. We got to look through them ASAP. The important things to look through are A, the financials. Make sure that the monthly fee that's been represented in the MLS is accurate. Oftentimes it's not. Make sure that the financials, that there's adequate reserve funds for the association. You can find that in the budget. Just make sure that they're on solid financial ground and that there's not a special assessment that could be forthcoming that can be quite substantial. Make sure that they're in conformance with the covenants. There should have been an inspection done that's made part of it to make sure that, you know, their paint is conforming, that there's no violation of the HOA guidelines. You know, many times there are. It's not negotiable. It's not negotiable. That seller has to make those repairs. If there's a big tree that needs cuts down, they've got to take that tree down, or they've got to get it removed from the docks prior to settlement. If that's the case, simply make the listing agent aware of the fact that those violations exist and you're looking for them to be taken care of. Prior to settlement, they've got to deliver to us something stating that those are removed. If they're not, then our buyer is automatically assuming responsibility for those items, and that's not fair unless it's been agreed to contractually ahead of time. Their buyer has 72 hours to review those docs from the time that they are delivered, not the time that they get them, from the time that they are delivered. So if they're delivered at, you know, X p.m. on Friday and the seller doesn't look at them until such a time on Saturday, that time started the day before. So it's imperative on us to make sure that they're aware that they've gotten this. It's imperative that we look through, because they're looking at stuff that's foreign to them. We're looking at stuff that we have some sort of familiarity with. But we also tell them, say, hey, we're looking at this. This is what we're doing on your behalf. But we're not taking responsibility if we find out that they can't put, you know, some paint color that they want on there. They have to take responsibility for it. We're just going to look at some of those main things, make them aware of. If they do want out, got to react quickly. You know, I mean, again, we're on a 72-hour time frame, and I've had agents come back to me on the 4th day and want to get out. Well, too bad. You can't get out. That's not the way that it is. The Condominium Act, which is the following paragraph on paragraph 9. Exact same thing, except it's a condominium. Some places, i.e. Reston, or that you can have both an HOA and a condominium. And you know, obviously you're wanting to check that the fees are what they were represented. On a condo, there's not necessarily a responsibility for conformance, but there can be, you know, bird feeders that are hung on balconies that shouldn't be there, or a grill that shouldn't be there. But it's in a condo where you're more likely to find a special assessment or something, you know, in the prospective budget that can mean a special assessment is coming. And the same thing on the docs. We always put the buyer's email, then our email. Paragraph 10, property maintenance and condition. Except as otherwise specified herein, seller will deliver the property free and clear of any trash and debris, broom clean, and in substantially the same physical condition as determined on the date of either the offer or the home inspection. Seller will have all utilities in service through settlement or as otherwise agreed. Important stuff there. Prepare the buyers. Doesn't have to be professionally cleaned. That may be how they would leave the house, but it just has to be in broom clean condition. Make sure they're aware of that. And broom clean can be a broad term. You know, there shouldn't be a pile of stuff in the corner, but sometimes, you know, they move a big heavy piece of furniture and they don't come back and clean, and there is some stuff piled in the corner. But it's also, it states that the seller has to have the utilities on through settlement. So when we show up to do a walkthrough, those utilities have to be on. It's incumbent upon the seller to have that in place. And it's incumbent upon us telling our sellers to do that. Many sellers, well, settlement's on a Friday. I can't turn them off until Monday. They'll get a whole weekend worth of my free time. Yes, they will. I mean, I don't know any other way to say that. But from a buyer standpoint, it's always good to encourage the buyers ahead of time, you know, about 2 weeks prior to settlement. Call the listing agent and find out who the utility companies are if we don't know. Call the buyers and tell the buyers to, hey, make sure utilities put in their name as of the date of settlement. So that way, it's always a problem if utilities aren't on, so that we can do our part to try and avert that. But that's the legalese there. There's a hold harmless in there for the broker in that paragraph, because we're not responsible for what that condition is. It also talks about it's determined whether the contract is contingent or whether the buyer waives the opportunity to make the contract contingent upon a home inspection. If the buyer desires one or more contingent, then such contingencies must be included in an addendum to this contract. So there's a home inspection addendum, a radon addendum, a well addendum. There's all kinds of different addendums, but if they want to do something, if they want to have a home inspection, there's an addendum to do that. But this is where they're checking it is contingent or whether they waive their opportunity. They're also, the buyers acknowledging that except as otherwise specified in this contract, property including electrical, plumbing, existing appliances, heating, AC equipment, and fixtures shall convey in as-is condition as of the contract settlement date. That's where it's spelled out in there. Seller is agreeing in paragraph 11 to give access to the property, to provide the broker, the buyer inspectors representing the buyer, you know, the appraiser, etc., reasonable access to the property necessary to comply with this contract. Does not mean that the buyers get to go back in there. Buyers don't get to go back in there, and it's kind of sneaky to try and sneak them in on one of those inspections. I mean, home inspection is their time to look. If they waive that home inspection, you know, you can call that agent up and ask if they can bring their daughter by, or their son, or their parents, you know, just to look at the property. But you need to prepare the clients that that may not happen, because most sellers don't want that. They've got that, they have that house all professionally staged and cleaned, and when you came in to buy it, and then they start to pack, and they don't want you in there when it's all tore up. And also, some buyers use that as an opportunity to do their own home inspection. They're looking at it with a fine eye on different things. It also stipulates in that paragraph that the buyer and the buyer representative will have the right to make a walkthrough inspection within 7 days prior to settlement and or occupancy. So you can do multiple inspections if you want, but you get to, what I would always do one the day of settlement. Go by the day of settlement, make sure the home is still standing. I've had one flood, I've had 2 flood, and I've had 1 burn. That kind of stuff happens. So you want to make sure it's still standing. And B, you want to go through maybe a little ahead of time to make sure if there was a list of home inspection items, they should get to us receipts. Whether they have or haven't, it's good to go by and schedule maybe a couple days ahead of time or a few days ahead of time, up to 7 days ahead of time, and make sure that work is done to your satisfaction. Because if you go through 7 days ahead of time, they have the ability to get work done prior to settlement, so it won't cause a problem at settlement. If work is not done that they've said that they were going to do and we have a dispute, then we're fighting about it at settlement, and then it gets into having to escrow money and having to get estimates and us not having control of the property or them not, it becomes a nightmare. So if there's issues that need resolved, we need to try and take care of them as soon as we can. And this is the paragraph that gives us access to the property to do that. Paragraph 12 is straightforward. You're spelling out what utilities are on the property. It's important to get that accurate, and it's important to have it filled out. Some homes have 2 types of HVAC, gas and a heat pump. So note that in there. You note what the water supply is. Is it public, or is it private well, or is it a community well? It's rare that we have, you get out into a more rural area, you can find a well, but we've got them right here in Centerville. Same thing for sewage disposal. It's got the type of heat, and as I said, some have gas, some have electric, some have gas and heat pump. 2 zones. One's up in the upper attic and one is serving the main body of the house. On the septic, put the number of bedrooms that are being represented in the contract. Put that in there, that it has to have a septic for 4 bedrooms, has to have a septic for, or an alternative septic for 4 bedrooms or 3 bedrooms or whatever's being represented. That is a protection, and we want to make sure that that's established. That also gives us an out if the septic inspection's done and it's determined that it's only a 2-bedroom perk and you got a family of 6 moving in there. Can be done, but it shouldn't be done, and they should at least be made aware of that, and we should at least have a contractual out, and the way to stipulate that is to put the number of bedrooms in there. Personal property and fixture, no bigger pitfall in the contract in my opinion. It stipulates built-in heating and central air conditioning, plumbing, lighting fixtures, sump pump, attic and exhaust fans, storm windows, storm doors, screens, installed wall-to-wall carpeting, window shades and blinds, window treatment hardware, smoke and heat detectors, antennas, exterior trees and shrubs. Unless agreed to in writing, those all convey. I've had people take shrubs, I've had people take trees, I've had people take light fixtures, I've had people take appliances. That kind of stuff happens. This is where the contract gives us the teeth to say, hey, this is also at home inspection. Have the clients walk through and video the property, and not video it to be a pretty video that they're going to send to their relatives. Get one that covers, what light fixtures in there, what wall switchers. I've had numerous battles over outlet covers or switch plate covers where, oh no, that had Billy's name on it. Well, it was what was there. When what you put back's a piece of junk. We want the one with Billy because our son's named Billy too. Those kind of things. You want to make sure that they understand, like window treatments. If the window treatments don't convey, they still have to leave the window treatment hardware. You can't go into a house and find big holes above each window where they took the hardware down. They have to leave that hardware. It may be cheap stuff and your buyer doesn't care about it, but the fact is sometimes it's very expensive stuff, and you buy enough of that cheap stuff, it becomes expensive. So they can't take that. It also states any surface or wall-mounted electrical components do not convey. So you get these wise-ass buyers that turn around and say, yeah, I guess I get, they can't take that. They took the wall TV. They can take the TV. They can't take the mounting bracket. They can take, the speakers out of there. They should leave the speaker cover over the hole, But if there's surface-mounted electronics, it can be removed. If the speaker is recessed into the wall, that's not something that they should take. They can take the surface-mounted ones. I should explain that further. All related mounts, brackets, and hardware do convey by virtue of the fact that they're attached. When you get to the next page and you see the check boxes next to everything, when you're filling out the contract, everything gets a yes or a no. The little blank next to that is so you can put a number. Are there 2 refrigerators? Are there 3 refrigerators? How many garage door openers are there? How many remotes are there? How many sets of gas fireplace logs? You have a house with 2 fireplaces and they both have gas logs in there. You want to stipulate 2 in there. Same thing with the refrigerator. If they've got a refrigerator in the kitchen and they've got a refrigerator in the garage and they've got a refrigerator down in the bar area, make sure that you've got 3 in there, because otherwise one's going to get taken. Washer and dryer, a big thing. Everything gets checked yes or no. Yes or no. If there's multiples, put the number in there. Window treatments are referring to the drapes and that's not referring to the hardware. Again, just to emphasize that. Other, which is right underneath there, other is where you put anything that's being conveyed or sometimes asked for, and you always discourage a buyer from asking for that, but anything such as lawn furniture or a pool table, that kind of stuff. Sometimes that kind of stuff conveys. If there's shelves that are in the basement and they're not built in, and your buyer wants them, this is where you put it. Anything that the seller has said, yeah, that conveys, this is where you put it. But put it in the contract, and don't just take word for it. Fuel tanks. Rarely do we run into this around here, but you go right down to Clifton and they've got oil tanks, they've got propane tanks. The important thing to note in that is whether it's leased or whether it's owned, because you can buy them from the company or you can lease them from the company. But also, anything left in the tank becomes the buyer's property. So the seller can't come back and say, well, I just put 900 gallons of oil in there. I want compensation for that. Nope, that becomes the buyer's property. Leased items. Leased items are something, maybe it's a propane tank, maybe it's a water treatment system, maybe it's an alarm system. Any leased item systems or service contracts do not convey absent a specific contract that allows for that. But if there's anything that's leased, like a water treatment system or that, and if it's leased, this is where they should note it. They can't, if you go through and you see an alarm system in the property and you're assuming that that conveys and you're checking the box up on the top that says that it does convey, it doesn't have to be working, but if it disappears because the alarm companies come to take it because they're no longer going to fulfill the terms of their contract, then that's a point of discussion. That's something we would have to cover. IRS FERPTA, that is the Foreign Investment Reporting Tax Act. That's withholding taxes for a foreign seller. Always, 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 always fill this in. And I would put that the seller is a foreign person. Even though we don't know, fill it in so that it's not a blank in the contract. Because if the seller is not, then we want the ability to negotiate and make sure that they have made provisions to pay the withholding tax. What that means is when there's a foreign national that may be going back to their country, wherever that country is, England or Canada or, Botswana, who knows, whatever country they're going to, if they leave leave our country, they can avoid paying taxes. And the country doesn't want them to do that. So when they sell their real estate in the country, they up to 15% of that money can be held if they are a foreign national. Now, again, it's another reason to use RGS. RGS has protections in place. Some of these little podunk companies and some of these little companies that may cater specifically to foreign nationals, you know, we don't want that. That money can come back on the buyer. It's not something, you wouldn't think that that would be the case, but IRS is funny in that way, and I checked with Bill on this. They can come after the buyer unless there's proof of that has been paid. So, another reason for home field advantage, but a reason to always check that box, even though we can say we don't know. If we check is, it's up to them to say is not. And the settlement, by having home field advantage with RGS, we'll know that we're doubly protected. And I guess further explanation, up to 15% of the seller's proceeds can be held. And if the seller doesn't have that, that can come back on us. But paragraph 15, buyer representations. Buyer will or will not occupy the property. If it's an investor, they will not occupy the property. If they are going to occupy the property, obviously they will, and that'll be their principal residence. You want to check that. That'll specify the type of loan that they can get, because if they're an investor, they pay a higher interest rate. But more importantly, it goes further in here to say, unless specified in a written contingency, neither this contract nor the financing is dependent or contingent on the sale or settlement or lease of another property. We always have to ask that. I mean, people can qualify. We could get somebody on a sign call and they've already been pre-approved with another company, and that company says, yeah, they're good to go. We turn around and write the offer, and we find out they're good to go once their home settles, their home's under contract, so they didn't feel that they needed to disclose that to us. We got to ask that kind of stuff. Do you currently own now? Yeah, you're in a rental. That's all we got to ask. Just make sure. Oh, yeah, we own our own home. Are you going to sell it? Oh, yeah, we need to sell it to buy. Well, then you know. We have to disclose that. That's where this is covered in the contract. This is kind of a hidden little contingency down here, but it's something that the buyer has to represent. And that can be a lease on a property as well. And it's protection for the buyer, but we need to do due diligence in asking that. And it also states that the buyer acknowledges that the seller is relying upon all of their representations, including without limitation, the accuracy of their financing and credit information is given to the seller, the broker, or the lender by the buyer. Paragraph 16, smoke detectors. For a seller, smoke detectors have to be in working order. Not a negotiable item. Oftentimes a home inspector says, oh, those detectors are past the 10-year mark. Well, it doesn't mean they're not working. They have to not be working to be a violation of this. But if we have a no home inspection contract, and we go in and take a little stick and beep, and it doesn't make the beep sound, and the thing's not working, they have to fix it. Doesn't matter. It's not a negotiable item. So sellers need to be aware of that, and as a buyer's agent, you need to check that. Lead-based paint housing in paragraph 17, they can check the box either were or were not constructed prior to 1978. 1978 is when the lead-based paint rule changed, so anything prior to that could have lead-based paint, and anything after that shouldn't have lead-based paint, because in theory, lead-based paint was no longer being produced. There is property that is considered target housing, which means anything prior to 1978. There is a form that can be found in the Long & Foster website, the sale and disclosure of acknowledgement of information on lead-based paint. The buyer needs to be made aware of the risks of lead-based paint. This paragraph also says the buyer does waive the risk or does not waive the rights to have a risk assessment or inspection of the property. If not, if they elect not to, then a copy of the sales contract addendum on lead-based paint needs to be given to them. But the lead-based paint pretty straightforward. You know, I mean, I just went through a property that had a test, and they came in and it was so much better than the one that I had done 30 years ago, you know, where they actually probed all around. If there is lead-based paint, it's very expensive if they want to get rid of it. And unless your kid's eating the trim or something, I don't know why it would be a concern. But again, not something we deal with in Centerville all that much. But you get out into places in Chantilly, and then it's a possibility. You get right there in Country Club. There's some that were prior to that, but you have to assume that in 40 years there's however many coats of paint over that trim. Wood destroying insect. Anytime a property changes hands, it has to be inspected. The lender requires that it be inspected. Not all lenders and not all loans require that, but the majority of them do. Typically, that is the seller's expense. Sometimes a buyer says, I want to take charge of that, and sometimes they waive the right to do that. Sometimes a cash buyer will not, they don't have to, but they still want to get one. So it all depends. My belief is it's a good idea to get one. You want to have that because it's required by the seller to fix that if they do it. But let's say it is done by the seller, they will furnish a written report from a pest firm dated not more than 90 days prior to settlement. So settlement becomes the date that we look for. It has to be done within 90 days of settlement, the test, showing that all dwellings and or garages within the property, excluding fences or shrubs not abutting the garages or dwellings, are free of visible evidence of live wood-destroying insects and free from any visible damage. It's not just termites. It's carpenter bees, carpenter ants, powder post beetles, acrobat ants, obviously termites. I mean, there's a lot of things. If they do find evidence that they are active, or that they had been there, chewed up something and left, seller has to fix it. It's not negotiable. The next sentence says, any treatment and repairs for damage identified in the inspection report will be made at seller's expense, and seller will provide written evidence of such termite and or repair prior to the date of settlement, which shall satisfy the requirements for this paragraph. Not negotiable. Best $45 any buyer ever spent. So the buyers can do it to protect them. If so, you need to make arrangements for access. I hate when agents say, yeah, the buyer's going to do it, and then next thing you know, I've got to go meet the inspector to let him in, and I've got to be there with the inspector when he does that. It's a real pain. It's also something that you can get some of these companies, and they charge $45 to go out and do the inspection. That doesn't put gas in their car. That doesn't pay the guy's wages and the upkeep on an automobile. They want to find bugs. So it's good to go and see what they found. If our buyer buys a property that had carpenter bees in it, and they drill this little round hole in fence posts and siding and all kinds of stuff, and it's treated, tell the client to make sure those holes are filled and painted over. If not, then those same holes the inspector's going to see, you know, when they go to sell the property in 10 years and make them get a treatment for it. Also, oftentimes these termite inspectors are saying, yeah, well, in order to be able to give a warranty, there's nothing in this contract that requires them to give a warranty. So the buyers can't expect the seller to pay for them to have a warranty. We can pay to have the termites corrected, and they also don't have to use, if we have it inspected by our guy. And so the way that I suggest that you do that is, when we have a home inspection, schedule the wood boring insect inspection at the same time that the home inspection is going on. Then all parties are there and everybody can see if there's any issues, and it can be made part of the home inspection for that matter. But that's the easiest way to do it, so you're not making multiple trips, and everybody's there to actually see what the issue is. Paragraph 19, damage or loss. Damage or loss remains with you through recordation. The way that the contract reads is, it said, the risk of damage or loss to property by fire, act of God, or other casualty remains with the seller until the execution and delivery of the deed of conveyance to buyer at settlement. At settlement, our buyers are going to have to come to settlement or provide to the lender ahead of time to have proof at settlement that they have insurance on the property. So the buyers are protected as of the date of settlement. We always counsel our sellers not to cancel their insurance until after they have their check in the hand, and then they call and cancel it. Also, the title company will call and get a payoff from the insurance company what's due. So they'll be notified, but damage or loss remains with the seller through recordation. Typically, recordation doesn't happen until the next business day. And what that is the worst case I can remember was many years ago. We had, April 21st was a Friday, and I had 3 settlements that day. And that afternoon, a massive hailstorm pummels Virginia Run especially. It was big hail, and it did a massive amount of damage. And I had to call the sellers and say, hey, we've got a problem. Likewise, I had to do that because I'm sitting at settlement, and the buyer said the awnings are shredded, the screens are shredded, the siding's dented, the roof has been pelted, the light fixtures are dented, everything's trashed on the house. And it was between insurance companies, but at the end of the day, it was the sellers that had to pay, not the buyers, even though both have insurance in play at that time.